As a legal practitioner, that makes it interesting that you would love to lend your voice, when it comes to the issue of violence against women. I'm going to give you the floor now. What's your take on this? And then legally, what do you think, the option available for victims of abuse? What would be your counsel to them? Because most of the time, because of the stigma, they are being told to keep quiet or not to talk or not to express their view. What options are available for them legally or in the society in order to tackle this negative development?
Entirely, the reason I even opted to make a statement on this topic at all is because of the emergence of the Violence Against Persons Property Protection Act. That's the VAP Act. It's not being used. I believe it's not being used enough because the VAP Act, unlike the Criminal Code and the Criminal Code and Penal Code, has gone the extra mile to define rape. Now, usually victims of sexual violence are suppressed because they would say the type of violence you've experienced is more of sexual assault rather than rape. But the VAP Act has gone to the extent of defining rape beyond penile vaginal entry and to other types, which even covers young men and men as well. Because usually the definitions that have been found in the Criminal Code and the Penal Code have been limited to men and women, and that's an adult man and an adult woman. But the VAP Act goes to define in detail other types of sexual abuses that could be categorized as rape, and that's on the subject matter of rape alone. There's also intimidation and other things, which I believe that I should put out there for other lawyers and other people who have been victims of abuse generally to exploit within the VAP Act. VAPP Act. It is where you can find more grounds to bring actions to court to plead your cause and to bring, because it's tried law and it's settled fact that a person cannot be punished for an offense that is unknown to law. So a lot of offenses have now been made known to law through the VAP Act, and that's why I stated that I would like to make a brief comment on violence against women as well. Thank you very much.
All right, thank you. I want to ask, when you talk about abuse, it seems like there isn't a clear understanding of what abuse is actually. That is why some persons don't even know when they abuse people, or even the abused don't know they're abused. Could you tell us exactly what can constitute an abuse?
Well, abuse generally is infringement of another person's peace of mind, the infringement of another person's privacy, the infringement of another person's regular day-to-day activity. Abuse generally can come in different forms. They can come in physical abuse, they can come mental abuse, they can come emotional abuse. Abuse come in different shapes and sizes. So it's only a person who has been abused that can actually state how they have been discomforted or they have been put into some sort of disarray by another individual. Abuse would include assaults, batteries, and many other things. So the range of abuse is actually a wide spectrum, which is, again, why I'm a major proponent of the VAP Act. It's something that every lawyer should study. It's something that every possible abuse victim should look into because there are many angles to bring in the definitions and the expressions of an abuse.
All right, before we delve into the issue of intellectual property, I would like to have your take because of your legal background. Most of the time, we discover that when the abused wants to seek justice, the issue of evidence is usually a challenge. What provision of the law is available? Can they take advantage of? And then what's your counsel when it comes to the issue of gathering evidence in order to buttress their cases in court?
Well, in this instance, I would say you might have to book a session at my office. That's number one. The truth is, in protection of evidence, usually in instances of abuse, it is about acting fast and acting immediate. Usually when a person has been abused, especially, let me stick to maybe physical abuse, or in an interesting topic of sexual violence, it is to secure the DNA of the other party at the earliest instance. In an instance of physical abuse, it is to arrive and take note of the things that have occurred at the earliest instance and include a third party who would also depose to an affidavit of having witnessed those facts, such that in an event where my nose got broken by another individual and I'm looking to sue him for the physical abuse, I have to visit a hospital at the earliest. I have to get medical attention at the earliest and get that medical practitioner to also depose to having treated me at that time. Therefore, there's timestamp and there's also the witness who is a third party, who is neither my friend or his friend, who's only deposing to the truth or the fact that they have experienced in person.
All right, so let's move on now to talking about Intellectual Property Act. What is intellectual property? People do different kinds of trade and business. What is intellectual property, and what does the Act say about intellectual property? How does the Act protect intellectual property of people?
Very good. Intellectual property generally is a person's, like the word states, intellect property. It is a provision of or a representation of an individual's talent, an individual's intellect, and an individual's production of an inherent gift. And the law provides and protects those gifts through copyrights, trademarks, and patents. Now, certain individuals are, and in this current day and age, they are more common. They are called creatives. They produce certain things from their intellect. We have artists like Odumodu Black, Replay, who are giving us a new wave of music. We have tech people like, Piggy Vest, who have given us a new wave of spending and saving money. We have all sorts of people who have brought out intellectual property, creatives in this modern day. And the property of this person is supposed to be their absolute control to give out and to control how it is being used. So intellectual property protection, generally, it is the protection of the artist or the creative's intellect and the control of how it gets out there and how it is used. You know, back in the day when we used to have Alaba markets ruling our music industry, a person goes to the studio, sings a song, and before he's done pressing save on the computer, other people have started hearing his song. There are times where you want to make different, you want to readjust your music. You want to redo certain things, and you don't have such control because other people have taken your intellectual property and they have put it out there against your will. It is necessary that an individual has control over how his intellect and how his own message goes out into the world. I think it's just fair that we have the Copyright Act of 2022, which has now rebranded how a person can make actions for an infringement on his intellectual property. The Copyright Act now provides for more stringent punishments for infringements on copyright acts. And I dare speak of SMADA A, which is the current wave right now of Pokoli and SMADA, who have gone to redo a South African song that is currently trending on Twitter, and I think they have a lot to answer for it. Things like that are very easy to infringe. A person's intellectual property is not a joke. When a person puts out literary works, copyright works out there, it is not for people to take and misuse however they see fit. So intellectual property protection is a very necessary aspect of law to safeguard the sanity of talents and creatives. Thank you.
All right. I would like to ask of your observation about the approach to intellectual property in Nigeria. Do people really have the necessary regard as expected for Intellectual Property Act in Nigeria?
Well, people are coming to right now. I'm sorry, I think I even entered this topic while I was talking about the first one. People are coming to learn of it right now. People are coming to right now. Especially with what has happened to Pokoli and Smada. People are coming to learn of the need to respect other people's intellectual property. And for the fact that the Copyright Act of 2022 has included more punishments, more damages, including jail term, possible jail term, it has made it a more serious offense to infringe another person's copyright or intellectual property generally. Now, currently, there have been a lot of instances of people making it on the news where an artist goes and makes an instruction for a song to be taken down because he didn't give permission for their intellectual property to be used in a certain way. For instance, like the same instance I've been speaking of, it is because Coco Lee is a person who's he's a hype man, and while at the party he was shouting, they were playing the South African song, and he was hyping another artist who's smarter, and they decided to go into the studio and make it an actual song. Now, if they had left it at that video, then it would have just been a hype man doing a hype man thing. But now that they have gone ahead to make it into music, they have now infringed that other person's intellectual property. And these are the things that the law protects against. Now, the fact that it is going around, and you know, us Nigerians know how to make a joke of a lot of things. Despite the fact that it is being a joke right now on Twitter, and we're laughing at Pokoli and Smada and making jokes about how they'll be in prison, you know, entertaining prisoners. The truth is, a lot of people are coming to learn and know that for real, if I actually take another person's song and make it into my song without giving them due recognition, as according to Section 3 of the Copyright Act, and I don't give them or call it a cover like it is, and then that means I can actually get in trouble. So people are coming to learn of things that can happen to them. And you can hear it here first. For free, there's jail term involved, possible jail term involved.
All right, so how does the owner of the intellectual property ensure that they have copyright to it? Is that actually like a symbol you could put, or there are steps you take to ensure that this is my work? You cannot have access to, you cannot reproduce, or you cannot make use of it without my permission, or the law by itself ensures that right?
Okay, so very beautifully, I'm going to go through the registrable intellectual properties for you. I'm going to go through that for you. Copyright is usually for literary works, musical works, artistic works, cinematography, sound, recordings, and broadcasts. Trademarks, on the other hand, registration of trademarks. So registration of copyrights are for those literary works, maybe artists and singers. Then trademarks are for marks and logos. I'll tell you this, I've registered recently a couple of events. Events now register their logo and their name and their slogan. Because people now have gone to the extent of using another person's event name to publish and to push their own event, which is an infringement of that event, the original event's trademark. So a trademark is an insignia or a sign or a logo or a mark that signifies another person's business or another person's intellectual property. Now, things of this nature are meant to be registered and protected. So there's the Trademark Act for that protection. There's also patents, and patents goes to the extent of protecting innovations, inventions. Those are the patent registrations. And patents go to the extent of even giving you monopoly of use over a long period, over everybody else. But patents cannot be left to only one person for life. That's the difference with patents. And then finally, in Nigeria, there's another interesting registration of intellectual property that we have, that is industrial designs. Now, coming down to all of this and to answer your question, to protect a person's trademark or to protect a person's logo or sign, then you must register what is called a trademark. When you register your own trademark, you must find a lawyer competent who will do a search to make sure that there is no such other insignia existent, registered, and available in the market. Then he can register your trademark to your name and to your brand. Thank you very much.
All right. As a legal practitioner, I would like you to tell us the consequences of infringing into someone's intellectual property, you know, as made by the provisions of the Act, you know, guiding intellectual property in Nigeria. What are the consequences?
The consequences are many. Like I told you, in the Copyright Act, the all-new Copyright Act that is being promulgated now, there is possible jail term. There are more grounds for you to seek for damages. I mean, all of the songs that the Smada have accumulated will be given back to the real and original owner of the song, Smada, once the court declares that there has been an infringement. So the truth is, when you go ahead and steal a person's intellectual property, you might eventually just be working for somebody else. You might just be the monkey that is working for the baboon to chop. In the event that when the person goes and makes actions for his intellectual property, you will end up having to give all you have earned using his intellectual property back to him, and even more, and even possibly go to jail. So there are a lot of things that you have at stake. Why don't you settle down and pay a ghostwriter to write for you, and that's your own original work? Why don't you settle down and maybe hope to God for talents to be able to create rather than steal a person's intellectual property? Then there's royalties and there's profits and there are many other angles where a person can recoup and regain and benefit of his own intellectual property. Thank you very much.
All right, still on intellectual property, let's assume, for instance, I'm an artist. I have recorded a song, or maybe I have written a song, but I wasn't the first to maybe legally have a copyright for it. And years after, I was the person who wrote that song. I also, by some way, maybe wrote something similar to that song. And years after, someone else is claiming to have been the first to have that particular idea or done that song. And it becomes a legal battle. I'll give you an instance. For instance, you find that an artist has recorded a song, and then somebody else is claiming that that's my song. Most of the verses are verses of the song that I have done. But there is no actual legal document that shows that this thing was done by you first. So how then can it be proved that it was stolen, or this person was the first to do it? By that I'm asking, for intellectual property, maybe of songs, maybe of written works or other artistic materials, how do you prove that I am the first person who has innovated this? I am the first creator of this. Does it mean that for every work, every literary work that you create, you document legally to show that I am the original owner of this work?
Very beautiful question. This question has brought us to a dicey situation. Honorable mention to blackface. This question has brought us to a dicey situation. Well, the only registrable intellectual property that recognizes the act of first in time is industrial designs. If I come up with an industrial design, for instance, typing in my shirt, and I register it, but it has actually been innovated by another person, but I was the one who registered this industrial design, then I own the industrial design, but only for a specific period of time. Now, other intellectual properties, I would advise actually that you register the moment you create. You get a lawyer, you have an intellectual property lawyer on your team. There is nothing more beneficial to an upcoming artist or to an artist generally with beautiful talent than having a lawyer specifically for your protection of your intellectual property. There's nothing that will profit you more than that, because what you think you're paying to that lawyer is nothing compared to what you will lose when they misuse and they take hold of your intellectual property. Now, back to your question, specifically to tailor the answer to your question. There's usually timestamps for creation of literary works, especially with songs. If you go into the studio where that song was recorded, that computer is going to have a timestamp of the day that they began to cartoon. There is no way to get around that. There's a timestamp for all of these things. You can go to the producers, and if you can't take us to the producer's item where you originally invented that sound, then it belongs to somebody else. It belongs to the person who registered it. And even instances where you have to prove that that person gained access to your studio, or that person must have heard and be inspired by your sound in one way or the other. It is a very dicey situation to prove. So the easiest thing to do to avoid being involved in this dicey situation and to not become like blackface is to register as you create. You can't sing it enough. But the problem with us in Nigeria is we like our lawyers being avengers. We don't like our lawyers being guardian angels. We like them to be avengers. We don't walk along with our lawyers and create and work side by side with our lawyers. No, we go ahead, create a big problem, and then when the problem becomes yam pepper scatter scatter, we call a lawyer in to do a miracle, which is not always the instance. It is necessary that we register, and that's for copyright artists to register as you create, for patents to register as you create. As a matter of fact, patents are very difficult to get there. There's a rigorous process because you must prove such innovations and prove that it is not as a result of another person's inspiration, and it's that an independent idea to solve a problem on its own. And I'll tell you something very interesting about patents in Nigeria. You can't patent agricultural innovations. Yes, in Nigeria, you can't. So also, as a pointer to upcoming artists, it is necessary that your works are registered with Nigerian Copyright Commission. When you have your work registered with Nigerian Copyright Commission, especially for this question you asked, it already issues you a certificate, which is easy for you to dish out to anybody who has infringed on your intellectual property as a stern notification that this thing that you have infringed on belongs to me. And a continued infringement would open you up to legal actions, damages, and the likes. Possible jail term. Thank you very much.
All right, let's look at the issue of, let's dwell more on trademark and branding now. I'd like you to take us through the processes involved in trademarking any material or any creative work, and then what is the cost, and we'll also look at the impact on branding.
Well, I won't discuss cost with you over on TV. I promise I won't do that. But I will tell you what the process of registering a trademark is. Registering a trademark, sorry, excuse me. In registering a trademark, you must first conduct a search. When you conduct a search, then you are sure that that trademark or that, that trademark or the logo is not available generally. Then you must also make sure that you register your trademark under the classes that are specific to your own, which can lead us into another dicey situation because there are several classes, I think about 40 to 50, I don't know. There's a lot of classes which you could register your trademarks under. It is necessary that you get a competent trademark lawyer that will search for all of those classes that you can register your trademarks under. For instance, water bottling company can come under 3 different classes. I hope I'm not being disconnected. I apologize. So many different categories can create for different classes of registrations. So in instances like this, it is necessary that you get a competent lawyer to search for all of the classes which your registrations can come under. Once you do that, then you are good to go to register. When you register, you're issued a certificate. An approval, then eventually a certificate. When you have that certificate, then you have securely protected your trademark. I apologize for the disruption in service. Are you still there with me? Hello?
Okay, so it just happened that, okay, you're still with us. You're still with us. You're still with us. All right, so what are some of the challenges that businesses or even creatives can have with trademark and even branding, creating your own trademark? Sometimes the symbols, the logos all seem to be taken. What do you do?
Yeah, well, if it's all taken, then you find another one, to be honest. There's nothing you can do. But the real problem with this trademark is registration under classes. You must find a competent lawyer, that will find all of the classes that your trademark can come under. Because, for instance, and when I say classes now, let me make an explanation for you. For instance, when you're registering the trademark of, let me see, an event, because that's the most recent one I did. For instance, now that event now can also be under the class of maybe teaching. If you don't register it under like teaching and impacting knowledge class, that is for like, so it's like classes under trademark registrations. It's like categories. So if you don't register it under the categories of teaching, then you can't use that event to teach people when another person has registered his own trademark for teaching on that similar trademark registration. What I'm trying to say to you is this: I could be trademarked to host an event for entertainment purposes only. Meanwhile, another person is trademarked to do similar, but for teaching purposes only. So there are many other categories which a person can be trademarked under for several things. So you must have a competent lawyer that will find all of the possibilities and put them into one for you and just you, such that everyone else who wants to get into that idea would have to find something else entirely and not infringe on yours, or else you would serve him a notice and then he would be liable to pay you damages. Thank you.
Is there a way to check if a particular trademark has been used? Can this be done virtually, or there is some kind of list where you can check and know, oh, this has been acquired already, I need to create something now, so you don't run into trouble?
I apologize, you have to take the question again. You broke up a little, I didn't hear that.
Okay, I'm asking, in creating a trademark, is there a way to check that the signage, the name, everything has not been taken? Can you check that virtually, or are there certain lists you could go through, or your lawyer has, and then you'll know this hasn't been used, this has been used, so that the person or the business who wants to register a particular trademark does not ignorantly take someone else's trademark?
Yes, like I said, what you need is to get you a competent trademark lawyer, a competent intellectual property lawyer who will conduct that search for you at the Chamber of Commerce. Yes, there is a database of all of the registered trademarks in Nigeria. The real problem we have is information. A lot of people are not informed. There is a database for all of these information that can be searched, where your name or your logo can be put in to search. And that is the responsibility of a competent trademark or intellectual property lawyer.